So welcome back, everyone. We're live on Facebook, so hi to everybody out there. Like us and follow us. We're going to share the show later on. My next guest is a newbie with me. I have with me Jill Hudson, and she's the owner of Hudson Law Firm. Welcome to the show. I want you first off to tell us a little bit about yourself and what you do, what you focus on. Go ahead.
Sure. Hello. Thank you so much, Carol, for having me. Yes, I'm Jill Hudson with Hudson Law Firm. I am in the practice of estate planning, wills, trusts, powers of attorney, probate, trust administration, and veterans disability law. I'm from Arizona, born and raised, very, very happy to be an Arizona native. And military spouse. My husband retired as a Navy commander with 28 years, so very, very proud to
Well, thank him
service,
also
yeah.
for his service, but also for what you do.
Thank you.
Too.
Thank you. Yes.
Because
yes,
this
love
is
it.
interesting that you could be somewhere, and it's such a small kind of a world. You never know when somebody might be talking about them being in the as a veteran and being in whatever served their for their country, and things happen
Yeah,
now. But
absolutely.
also when it comes to estate planning.
Right.
Things happen with that, and I want to start off right without asking you a question that is
Sure.
not on your list,
Sure.
okay?
Yeah, absolutely.
I like doing that to people. And the thing is about when it comes to estate planning, that everyone seems to put their heads in the sand when it comes to this. Tell us why, and then also I want to know why it's important to go to an attorney.
Mm-hmm.
Okay, go ahead.
Absolutely. Okay. Yeah, I like your question, Carol, about when people want to put their heads in the sand. I think it's just, again, what you don't know. And there's some fear involved, right? So it seems very overwhelming. So a lot of people, when they hear estate planning, they think they must have to have this huge estate, tons of assets, tons of money. That's not true. Any estate, any amount of money, it doesn't matter how much you have, 1 car, 5 cars. It's really important to take care of what you have and provide for maybe your loved ones if you're going to want to give. And if you don't have loved ones, I have several clients, they are the last to survive. Well, they can choose charities, certainly, and that's very, very helpful for them and gives them peace of mind. That's really my goal. My goal is always to provide peace of mind where I can. And so then, yeah, the other question is, you said, why would you want to go to an attorney? Why, a lot of people try to do it themselves. And certainly they can try, but unfortunately what I have seen, and I've been doing this specifically since 2014, my law firm, but I've been an Arizona attorney since 1998. What I've seen is where they get it done either with somebody who's not an attorney, let's say somebody maybe who's not well versed in the estate planning world, or they try to do it themselves, let's say online, is there's a lot of problems, right? So I have to correct a lot of the issues. Thankfully, a lot of the clients come to me before it's too late. And I don't want to say too late ever, worst case scenario, but they're going to have to end up spending, their survivors anyway, would have to end up spending quite a bit of money if it was done incorrectly. So maybe they were trying to avoid probate. They had a trust, but it wasn't fully done. It wasn't fully funded. It was incorrectly established, wasn't even maybe executed correctly. So these are the things that's going to cost a lot more at the end or after somebody passes away. We're trying to avoid all of that. So that's the other question is, when you're saying, why should you go to an attorney? That's really why, is to make sure that it's done correctly.
There's absolutely, the best reason to go to an attorney is you don't know, you might be passed away, but you don't realize what happens afterwards. And I'm just going to give this as an example. My ex-husband's mother, who passed away, thought everything was all done correctly, and there's a stepbrother involved, and now, guess what? It's in probate. Okay? And, so even though you think it's all done and everything is fantastic, if you don't have an attorney helping you and it goes into probate, it's not good.
It's true, and it's so much more costly, so we're trying to avoid that.
So, what's the difference between a trust and a will?
Well, the trust gives you a lot of control, where you may want that control. So maybe you want your beneficiaries to have, to have to wait maybe to get some of the distributions. You want to have some controls in place. Maybe you need a special needs trust. Perhaps you have a beneficiary, whether it's a child or anyone, who is trying to, or you want them to have some money after you pass, but you also don't want them to get kicked off of maybe some public programs, okay? That's financially means tested. So I can work with all of that, right, certainly. But a trust, though, does give you that control. It also allows you to name a trustee, and they can help you even while you're alive. A lot of people don't realize that. So maybe you become incapacitated. More so than just a power of attorney, they can actually help you with your trust assets while you are alive. Maybe the home. Okay, so if the home is in the trust and your trustee can maybe bring in some long-term care help, whatever the case may be. It just gives you a lot more freedom, and you can name that person or persons to help you even while you're alive through the trust. The trust would own those assets per se. The difference with the will is there's really no control while you are alive, because the will only comes into play after you pass, right? Now, there is some sort of a misnomer I read everywhere where all wills have to go to probate. That's not necessarily true if, especially here in Arizona, if the person creating the will makes sure that every asset that they have has a beneficiary. So normally, okay, I can't say 100% of the time, but normally when there is a beneficiary, it's gonna bypass probate, okay? If there's assets to be able to name a beneficiary. So that can be very helpful. So again, I get clients who actually, unfortunately, they've met with an attorney, and the attorneys gave them their binder, gave them all the originals, whatever the paperwork, but there's a letter on the front of the binder that says, good luck, make sure you fund your trust, or make sure you've named your beneficiaries on a will. It was never done because the client thought it was all done for them. So something that I saw early on, right away when I started this in 2014, was that no, I'm gonna take it that next step. So everything that I do includes, like our last meeting, not only do they get the binder with their originals, but we schedule a meeting that's about 45 minutes, and it's called a trust funding meeting. No extra charge, but what we do is we go asset by asset, or if it's a will plan, we make sure that beneficiaries are named, because I want them to avoid probate.
That's awesome. Now, when you work with people, you say that you are statewide, you're located in Chandler, but you work statewide.
Yes.
You do free consultations. The phone number is 480-369-4802. And I mean, having a consultation is so important, folks, anybody that's listening. And I have to say, I don't know whether you do this or not, so I'm just gonna ask anyway. Do you do second opinions?
I do, yes.
Because, the reason why I ask this is, I told you before you came on the show, I already have one, and I had been having some surgery, and I thought, you know what, I'm just gonna look at it, make sure. Well, I'm glad I did, because I had that done 5 years ago, and guess what? There was so much to have to change. Life happens,
Right.
things happen,
Right.
you change accounts, whatever, and if you don't look at that periodically, you better dust it off and have it looked at.
Yeah, absolutely. I love that. That is a great opportunity. I'm happy to do that, review someone's trust plan and advise what I would change or not change sometimes, yeah.
So then, by adding beneficiaries, is that how you're gonna avoid probate?
Right, let's say you don't want a trust, or maybe you don't need one, because I will not upsell. So if somebody doesn't need a trust, I will make that very clear as to why I don't think they need one.
Mm-hmm.
We can do what's called a will-based estate plan, right? But we cover everything, powers of attorney, financial, healthcare, etc. But yes, so the way to avoid probate, I want to say most of the time, I can't say 100%, but the way to avoid probate in a will plan is to make sure that you have named beneficiaries,
Right.
correct, yeah.
I was gonna say, because there's a lot of people out there today that may or may not need a trust,
Correct,
right? But you should still have a will done,
Absolutely.
right? Everybody over the age of 18 maybe,
Absolutely.
okay?
Correct, 18 and over, because 18-year-old, yeah, a lot of parents, they send the kids to college, their guardians, whatnot, and there's a medical issue, they can, as soon as they reach 18, the parents cannot speak for them anymore about medical, financial, so very important, yes, so there's a bare minimum, really, powers of attorney and a will, you're right.
Right, and the other thing too is when this is for you, some of these things are for you, like when you discuss how people are incapacitated, okay, how do you talk to anybody, right?
Right.
If you have to go to the hospital and you have to, and again, even with that, I think something had come up with a bank account where they thought that everything, oh, no problem whatsoever, they had to hold on to it for like, I don't know how long it was, things like that. You have to make sure your I's are dotted and your T's are crossed, and using an attorney helps you make sure these things are done correctly, that you have, that you're thinking out for their best interest. That's number one, right?
Absolutely, 100%, yeah.
Okay.
Because not only for them right now, peace of mind, but after they pass, like you were mentioning about your families. So we want to avoid those problems as much as we can. So I'm going to give them the, okay, what if? And again, going back to your very first question about head in the sand, a lot of people don't want to talk about that. But it's really, really helpful, and then get it done. And like you said, 5 to 7 years, let's review. Okay, just review, see if there's been any life changes.
Mm-hmm.
Do you want to move people around? Maybe this person, you don't want them to be over your finances.
Absolutely. We're going to go to a break. We're going to come back. We're going to talk further. Probably the most important conversation that we have here is this kind of a thing. Because you know what? You guys, listen up. Don't put your heads in the sand. Let's get these things taken care of. Peace of mind. That's what she offers. Again, her phone number is 480-369-4802. Hang tight. We're going to be back in just a minute.
Perfect, thank you. Yeah.
Now, we're on live on Facebook right
Okay.
now, so we're going to keep on talking.
Okay, great.
I think that when we talk a little bit about these things, a lot of people think, like you said, they have to have money when it comes to, or even an estate, because it says estate,
Right.
that they need to have a home.
Correct, right.
You know, I think it should be rephrased.
I agree, yeah, and I try to, thinking about that.
I mean, it's
You know,
different.
Yeah.
You know, I mean, I know it says it, but it's like everybody that thinks about all of this with the trust and everything, that you have to have. Go ahead.
Right, no, yeah, I like
You
what you're
agree.
saying. Yeah, because you don't have to have a lot of assets, you don't have to have a house.
Right.
But again, that trust will give you some of that control. So some of my clients who don't have, let's say, a large estate, okay, because we have small, medium, or obviously, let's say a very small estate. Maybe you're renting, you have a car, maybe, okay, maybe a couple of assets, investments, whatnot, bank account. And yes, they could get by with a will, no problem. A will-based estate plan is fine. But maybe they are approaching getting a little older, maybe they're getting a little more frail, and they want someone right now to be able to help them get with, as a trustee, as their power of attorney, and then even for their care while they are alive, certainly, and maybe anticipating maybe some incapacity. So again, it does give you more control right now, a trust does. So that's kind of
I think
the
that's
difference in that
important
world.
too,
Yeah.
because, you know, there's a lot of people that, you know, maybe they have a little bit of dementia.
Exactly, right.
And they're not exactly sure what they're doing 100% of the time.
Right. That's another huge reason for this peace of mind before you lose capacity, ever, any. You do want to be able to name someone, because if not, and somebody does have complete incapacity mentally, then someone's gonna have to go to court. They're gonna have to actually petition the court for conservatorship or guardianship, and that's very expensive.
So, okay, let's talk about, there's a lot of people that do document preparing.
Sure,
Okay.
yeah.
Is this one of the reasons why they wouldn't wanna have to go to, like someone like that, go to an attorney where, because how do you appoint that person? How do you do that?
Well, that's a really great point. So you could either have somebody that you could want to name, or I'm sorry, if I'm an attorney or a doc preparer and I already know who those people are in their life, right, then they would step up and actually petition the court.
Okay.
Otherwise, someone's going to have to be appointed from the court, so like a public fiduciary, which isn't necessarily a bad thing at all. It's just, I would hope, because if it was me or my mom or, you know, grandparents, I would hope that we already have somebody in mind, right? Yeah.
Exactly.
Okay.
So welcome back, everyone. You know, when it comes to estate planning and wills and trusts and all of this that we're talking about, it can be confusing in its own way, but it's also important to understand at each step.
Correct.
Because it's kind of, like we were talking at the break, and like right away I'm like asking all of these questions, and yet at the same time, okay, I want to make sure I'm still doing it right. having a consultation with you is the first step to take, right?
Correct.
You do a free consultation. We talked about, you don't necessarily have to own a home, right, to have a trust.
Mhm.
So
Right.
we wanna talk about some of these different things and go, kind of like really help, because one of the things that I said to you, I used maybe like somebody can become, get dementia. And you said, oh, good, really a good point.
Mhm.
That is one of the reasons why you wanna be on top of this. Go ahead.
So before anyone loses capacity.
Right.
Specifically, of course, the mental incapacity, the person, I would want to name, right, my client, they want to name who's gonna be helping them financially and with healthcare decisions. Arizona, by the way, has two health powers of attorney. We have healthcare and mental health care. They don't have to be the same people. And my clients really, really appreciate me explaining that to them, because maybe you have a child that can't help you with mental, you wouldn't want them, and they wouldn't want, yeah. And they'll be happy with healthcare. But yeah, being able to control those decisions now before any potential incapacity is huge, so we can avoid having to go to court.
Mm-hmm.
Like I was saying, conservatorship or guardianship, you don't have to then spend that kind of money. You've decided ahead of time.
It's important.
Very
It's important. Again, her phone number is 480-369-4802. She does free consultations. She's located in Chandler, but works statewide.
Right.
So here's a good one. How do I plan for minor children should something happen to their parents?
Okay.
Okay?
Absolutely. So will, trust, whatever, however you want to approach it, definitely that's one of the first questions I ask is, do you have minor children? Or are you a guardian over, obviously minor children? So yes, you definitely want to prepare for who would be their guardian should the current parent or guardian pass away. And we can have backups. I insist. Some of my clients roll their eyes, they know, but I'm gonna always ask for a backup. Why? So we can avoid the expense later on of having to go to court, right?
Mm-hmm.
So we can already establish these backups. But yes, definitely we can provide for that. And in a trust situation, okay? In a trust, you can actually now put even more parameters around when these children, let's say, get their distributions. Maybe you don't want your children to have everything at 18, right, if you've passed away. Maybe you want to have some stair stepping. I work with every client. There's no one size fits all. That's why I don't have set prices forever, because you may not need what somebody else needs. So I'm going to just talk with you individually, create an estate plan that is yours, and that the fees are very reasonable, because, well, first I keep my costs way down, but also there's, again, not one size fits all.
Yeah, and it's very important too. I love that you do that, because you're personalizing these to every person.
Absolutely.
And like you said, not everybody needs it all, so you're
Right.
gonna work with each person on the pricing. That's awesome that you do that. Okay, so should I hold property with another person? In joint tenancy with rights of survivorship? Okay, if yes, who should that person be?
Well, you can hold, obviously you can hold property with joint tenancy in Arizona. You can hold it in tenants in common where you're split. You can have a 50-50, 80-20.
I don't know why they do it, because it's very nasty.
It can be.
It
Can be. So joint tenancy with rights of survivorship, or married couples can have community property with rights of survivorship. The key word I want everyone to know, because I have so many clients who were not aware of what was happening at the time. Maybe they're married, maybe not. Okay, this is usually, the questions I get are usually clients who are not married. Maybe they bring in a child, an adult child or whatever, to the deed. But survivorship means that. So if the first one to die, the other one is 100% the owner of that property, okay? So that, I just want everyone to be aware of that. They may be fine, but I review all of their deeds, whatever property they hold. We take a look at it, and I just ask, do you still want this setup? Yes, no, and how do we change it if I don't want it? But I just want to stress that. So survivorship means, again, first one to die, the other is going to get that 100%. And some clients think, oh wait, no, I wanted it to be split between all my children, but maybe only one of their one of the kids has the survivorship listed. Maybe they, for some reason, just put one of them on. The other kids are not going to get that property, and that actually can cause a lot of problems.
That's probate.
Exactly. That's absolutely probate. Yep.
You know what I also have to tell people too, probate can be, it can go a long time.
It can, right, and that's let me go back up on that too though, because when
ahead.
there is survivorship, yes, it'll transfer. So normally though, if it goes to probate, they may not win, right? The other kids may not win because there was a survivorship.
So
right?
no matter
Deed.
what, it said what
Yeah,
it said?
it says what it says. They can try to challenge it, but it's a little more difficult unless there's other documents. It's kind of a convoluted, obviously, probate process. It could be, but this usually does control. So that the deeds are going to be really important, and so I look at everything, right? The total picture. I don't just do a document and say, okay, you're good to go, because I want it to be a complete and thorough estate plan. This is just a question that usually comes up, and sometimes they're shocked. They didn't realize what they were signing. So, and that happens. So, the saying, right, you don't know what you don't know, but I really, really like the educational piece. So I try to make sure I'm very thorough, ask every question. I don't charge by question. They can feel free to ask me anything. It's very important, again, that peace of mind, and so I want them to know what everything means.
So when they come and you're gonna work with you, you're having a consultation with them, they come in, they sit down, what does that look like, do we have, by the time you start to finish, when it's, let's say, done? Does that take a couple of, how many, 3 or 4 times, or what does it look like?
Okay, great. So usually the first, if it's a call or an in-person meeting, I always prefer in-person. If they can't, they want to do Zoom, that's fine. If they're housebound, I come to them. I will make house visits, yeah, absolutely. That's very important to me to provide that. No extra fee for that. But yeah, the first meeting, no fee, obviously, free consultations. But that first meeting is, I like them to already fill out a questionnaire in advance, so we have kind of something to discuss and build upon, okay? And then we talk about that questionnaire. Who are your people? Who are your, let's say, trustees or your personal representatives? Arizona calls that. That's an executor term in other states. We call it personal representative. So that meeting is about an hour, let's say. The second meeting, if they retain me, is the signing meeting. I provide the 2 required witnesses, again, no extra fee. My clients are welcome to bring in their own witnesses. They just can't be related to them, right, by blood or marriage. And then that's also about an hour. And then our third meeting, again, is that very important meeting. I always tell them the most important is our last meeting, because that's that trust funding or how to avoid probate meeting. Very crucial. And I do schedule that for 45 minutes to an hour.
So important for people to listen up, and I think when people talk about estate planning, they think that when they do this, that it's gonna make them die.
Right. No, it's true.
I know, it's
I've
crazy.
had that. Yeah, no, I've had a couple of clients say, oh, I didn't want to do this because I was afraid that if I did,
I was gonna turn around and.
yeah,
Yeah.
and none, this has not happened to any of my clients. They
No.
have not, right, it doesn't, but there is a fear.
Question, a lot of people, we talked about the internet earlier, okay? They'll say, well, I can go up on the internet and do all of this myself. What are your thoughts on that?
I really, really caution against it, just because I've had to fix so much and it's expensive. I don't want to say they can't do it. I just caution. Maybe sit with an attorney. Maybe the attorney would be willing to, not charge as much if some of that work was already done and they could just review it. But there's so
Too many
much that's
mistakes.
missed, yeah.
All right, this is a good way. This is a good one, okay? How do you avoid family disputes?
Well,
Yeah.
This is so huge, and so it's an area I think that needs to be talked more about in the estate planning area, rather than waiting to family law court, right, or going to family court. But trying to talk to your people now, trying to talk to your family now. You don't have to share your documents, but maybe ask some questions or let them know what you're thinking, so that they have peace of mind after you die. So the siblings can actually get along.
Communication,
Yeah,
it's
absolutely.
what it's all
It's key.
about. You know what, this is an important conversation that I believe everybody should have. Whether it's for you or someone that please let's give them peace of mind. That's
Yeah.
what you said, that
Absolutely.
you're all about. I love what you do, because you sound like you really care and get really involved with each one of your
Absolutely.
clients. She is located in Chandler, but she does work statewide. She does do free consultations. You can call her at 480-369-4802. That's 480-369-4802.
Thank you.